The U.S. Supreme Court recently ruled in favor of Brandy Levy, a Pennsylvania student who had used vulgar language about her high school in a Snapchat message that she posted off campus. Her case drew interest from those who administer our public schools and from advocates of free speech for students. It was the spring of 2017, and Levy was a rising sophomore at Mahanoy Area High School who became upset that she didn't make the varsity cheerleading team, and she was frustrated with school in general. You probably heard about what her snap said. One of Levy's cheerleading coaches found out about the message, and Levy was suspended from cheerleading for 1 year. The coach said the vulgar language violated team rules and upset the other cheerleaders. But Levy had sent the message on the weekend, and not while at school. Levy and her father sued under the First Amendment, arguing that schools shouldn't be able to exercise such authority over off-campus speech. 2 lower courts agreed with the Levys. A federal appeals court said that the Supreme Court's famous 1969 Tinker decision about student speech did not apply off-campus at all. That case involved John and Mary Beth Tinker and a few other students in Des Moines, Iowa, who wore black armbands to school to protest the Vietnam War. The Supreme Court upheld those who had worn the armbands and declared that students had a right to free speech in school so long as school was not substantially disrupted. In Brandy Levy's case, the Mahanoy Area School District appealed to the Supreme Court. On June 23rd, the nation's highest court ruled for the cheerleader by a vote of 8-1. The court said that public schools may have a special interest in regulating some off-campus student speech, such as to prevent threats or severe bullying, but the school's interests in this case were not enough to outweigh Levy's interest in free expression. Justice Stephen Breyer said off-campus speech by students will usually fall under the authority of parents, not schools. Also, schools will have to meet a heavy burden to regulate political or religious speech that occurs off-campus. And Breyer stressed that schools themselves have an interest in protecting unpopular speech by students. Said Breyer, "America's public schools are the nurseries of democracy. Our representative democracy only works if we protect the marketplace of ideas." Breyer said Levy's Snapchat message did not really cause a substantial disruption at school. The lone dissenter was Justice Clarence Thomas, who has said before that he believes that students really have no First Amendment rights in schools. Thomas said schools have been regulating students' off-campus behavior for more than 150 years, and social media messages that originate off-campus often will have a greater proximate tendency to harm the school environment than will an off-campus in-person conversation. Brandy Levy, who's now in college, was certainly happy with the court's decision. Said Levy, "I was frustrated. I was 14 years old, and I expressed my frustration the way teenagers do today. Young people need to have the ability to express themselves without worrying about being punished when they get to school." The Mahanoy School District and some advocates for school boards and administrators said they were satisfied with the decision too, because the court did not set a broad rule that off-campus speech could never be regulated by school officials. The school district said, "The Supreme Court enumerated many examples of situations when school districts can regulate off-campus speech and made it clear that its list was not exclusive." Some legal experts were a little disappointed that the court did not go further to establish all-encompassing rules for the social media age. But as Justice Breyer put it, "We leave for future cases to decide where, when, and how a speaker's off-campus location will make the critical difference in whether schools may regulate student speech."